this week there's a lot of controversy around the Michael Hirokawa case. That was the Capitol Place sex assault case that everybody's talking about, and there's been a lot of controversy over the way that the bail is set. So I ask you, Ms. Cow, what are your thoughts on the case and the way that the bail was handled?
So I'm going to talk to you about it as from the perspective of a deputy prosecuting attorney or deputy attorney general. Then I'm going to talk to you about the perspective from a defense attorney.
All right.
And very often, governmental attorneys have never been defense attorneys, and so they don't see that aspect. But there are some defense attorneys that have been prosecutors or deputy attorney generals. So it's a very different perspective. So as the prosecutor or the attorney general, in our mind, when we charge a case, we look at it and, we set bail based on the facts and circumstances of the case, not necessarily whether the defendant can or cannot pay, the inability or ability to pay bail. Mm-hmm. And we ask the court to set it at that amount. And we don't think anything of it. If the defendant bails out and there's a grand jury indictment, often the prosecutor or the attorney general will come back and ask to increase the bail. And they don't think twice about it because that's the procedure that's been followed for years. And in the city or in the state, we continuously do things as they've been done before. We don't change things up, especially if there's not a real reason to change things up. And so we increase the bail as the governmental attorney, and then the defendant has to either go back to the bail bondsman and negotiate something else or pay a new bail. But the prosecutor doesn't think about that because the prosecutor's job is to be the attorney for the government. Mm. Now you look at it from the defense's point of view. So I'm just going to give you a hypothetical just so you can understand this. So, and this happened in the Kahala stabbing case. As a defense attorney, we look at the bail and let's say it's set at $500,000. And so we go to a bail bonds company and we assist our client in bonding out. They pay the $50,000 fee to the bond company, and now there's a bond posted. Mm-hmm. Then the government goes and gets a grand jury indictment and raises it to $1 million. Now, as a defense attorney, we're a little upset because our client already bonded out. We negotiated the bond with the bond company, and we arranged for our client to be bonded out. But now the government's coming back and saying, well, since you bonded out or you were able to bond out, we're going to increase the bail now. Yeah. And so as a defense attorney, it's not fair for our client because we've already bonded out. We've already paid the fee. Uh-huh. But prosecutors don't look at it that way because most of them have never been defense attorneys. And quite frankly, most of them don't care about where the defendant stands financially. And so they don't think twice about the defendant having to post yet another bond or post another fee to a bond company. So it's a little unfair, and I don't think governmental attorneys do it on purpose. I think this is just the way it's been done forever, and they don't have any reason to change that procedure, and so they continue to do it. So what happened in the Hirokawa case is I think it was set at $500,000.
That's correct.
He posted a bond, which means he paid a bond company approximately $50,000.
Yep.
Which he doesn't get back. Most people don't know that, but once you pay the bond company fee, you don't get that money back. Mm-hmm. Then what happened is the deputy attorney general filed a motion to hold the defendant with no bail. And so what that means is she was telling the court that this guy is such a risk of flight or risk to reoffend that we are asking to hold him without letting him post any bail at all. The problem with that, is this case did not qualify under the statute. And that was clear from just my knowledge of what the statute requires. The attorney general, I guess, felt she needed to file the motion for whatever reason, but the facts of this case don't meet the criteria. For example, the defendant has to be a serious flight risk, meaning that he's either facing life in prison or he's been convicted of other crimes to show that he's a flight risk. Mm-hmm. Or he's done something that shows that he's going to tamper with the witnesses. Mm-hmm. But none of that applied in this case. And so I'm not sure if I was the prosecuting attorney or the deputy attorney general, if I would have filed that motion.
Yeah, and I reviewed the motion just because I geek out on stuff like this. And it was cited that because he had been to Colorado and had flown to the mainland, now somehow because of virtue of being somebody who went to school on the mainland and having recently gone to Colorado for whatever recreational reasons it might have been, now he's a flight risk after being charged. I don't really like that little workflow, how it's set the bail first. Oh, wait, he posts the bail. Now let's go ahead and cry foul and try to put him in. And then if he happens to have taken a trip for whatever reason earlier, now he's a flight risk after being charged. I don't really like that little workflow. Do you think there's ever going to be like a change, now that we have a new administration coming in? Do you think there's going to be a change in the way that we charge people specifically like that?
No, I don't see that process changing with this new prosecuting attorney. He's never been a defense attorney either. Mm-hmm. And so he doesn't have that perspective. And like I said earlier, they don't really care. Even if they don't think twice about the fact that the defendant has paid a bond fee and will likely have to pay another bond fee, or will lose that bond fee if he's held without any bail.
Yeah, and that's unfortunate because I'm a bail bondsman, obviously. I've always felt like I lost a part of myself when somebody has put up so much money and they're supposed to be charged for a criminal act. It's separate. Like if you try to now, as somebody who's prosecuting on the criminal side, oh, let's go ahead and go after him financially too, mess with his bail, or just take away his right to bail after posting a tremendously high bail amount. I really feel like that needs to be brought up, and I don't know, maybe this podcast will help. You never know, right?
You can try to bring it up to the new prosecuting attorney and see what he says.
I will get on my soapbox and just try to make that happen, because there's so much involved in getting a bond that high. You have to have co-signers, qualified co-signers. Can't just be somebody off the street who knew the guy for a day or two. It's like parents got to co-sign. I bet they took a lien on a house too to guarantee that he goes to court. There's so much skin in the game to guarantee that he goes to court. And then it'd be one thing if he got rearrested for some stuff, but no, it's been 2 or 3 weeks, nothing's changed, and now they want no bail. I've always kind of taken offense to that, but anyway, we'll move on.
But Nick, I just want to point something out.
Yes.
That's perspective. A deputy prosecuting attorney and a deputy attorney general have no idea that it takes all of that just to get a bond signed. They don't know about co-signers. They don't know about collateral. They don't know about checking on property. They have no idea. They've never done it before. So it's a lack of perspective.
Okay. Very good.